as a solution and the transfer on death deed as a solution. Why am I talking about this? Because it came up today. It comes up from time to time when we have calls that come in and say, Mom's about to pass away, Dad's on hospice, and we don't know how long he has. And we're just finding out that his largest asset, his house, where he's on hospice, is not in a trust. It's just in his name. Literally, that was the potential new client call that came in today. And that sparks the question, well, what do you do? What is the right situation? What are the options in that scenario? So we're going to break this down. We'll break it down for you who may run into this out there. I'm going to break it down also for our professionals out there in the universe looking at this. So if you're coming to this video because you put in transfer on death deed, that's because you want to know more about it. That's probably because there is a situation of urgency that has come up and there's a house involved. And you want to make sure that the house is going to pass outside of probate. And there is very little time. What do you do? What are the solutions? Well, if that's you, or that is someone you know, or that's a client of yours, then listen up. In those situations, we have to be extra careful. Why? Because it's not that we avoid probate that we have to be careful about. It's that we set off a litigation landmine later. So we avoid probate in the immediacy, but we don't avoid the problem. In fact, in a lot of cases, we actually create a bigger problem if this is not handled with kid gloves. And every situation is going to be different. So this is not a solution for all of these situations. There are tools that we use that we have to assess and analyze what is the right fit. What are the tools? Well, of course, we have the revocable living trust that is going to avoid probate. Something is pared down, not complicated trust. Now, they can be complicated, but not this one. We just want to make sure that the homeowner has the house in the trust and that when that homeowner passes away in very short order, that it bypasses probate and goes to the beneficiaries named in the trust as managed by the trustees. Very straightforward. And if done correctly by somebody with experience to do this, it will serve that family well. The question is there enough time to get it done? And does the homeowner understand what they're doing? Are they in a position to understand? Cognitively, maybe that's because there's a illness like dementia, or cognitively because they're on a bunch of morphine and other drugs to make them comfortable. They're on hospice. So we have to make sure that we understand that situation and maneuver around it. So that may be a good option, may not be. If we don't have enough time, or if the homeowner is not really capable of being in a space and a mindset to understand what they're doing and understand all of the documents signing, because a trust is not just a couple pages. And there are lots of words there, and they have to understand the implications and the timing and the availability of an attorney to help. This is not something that you want to pull up LegalZoom documents for, or documents off the internet, or you want to use expert in this situation, particularly because of the things I'm about to tell you. Option number 2, transfer on death deed. Yes, it's a beneficiary on your real estate, right? Beneficiary on the house, just like a beneficiary could be on a life insurance policy, retirement account, or bank account. You could put a beneficiary on a house. Wow, that sounds great, Kevin. Super easy. Forget that trust. We'll just do a beneficiary. Well, that potentially is an option. It's not as simple as filling out a beneficiary designation form like with a life insurance policy or bank account. So there are other rules and lots of other hoops that people who do these deeds on their own just don't know, because you can get a transfer on death deed by just going to the recorder's office online. And most of them will have these forms that are available to the public that you can download and fill out on your own. Well, it could work out fine, or it could be like Mad Libs. And if it's Mad Libs, I'm sorry, it's going to be a problem, because when you realize that it doesn't make any sense afterwards as applied, there's no going back. The homeowner has passed away. We can't change things, and now we have a bigger problem. So we've got to make sure that we're dealing with that. That's a very hyper-technical procedure. So while it sounds easy, it's hyper-technical, and that's just not known. So this is not something you YouTube video and do. Meaning that walk through and watch somebody fill it out. Oh, I'm going to do it just like that. Hyper technical on the front end and the back end. And there are all sorts of problems. The third option is, of course, a quitclaim deed. I'm going to deed right before I pass away my house to whom I want to receive it. So it's not going to be owned by me. It's not going to be owned by my children. I've signed a deed that says I transfer it from myself to my children, as an example. That also could sound very easy. There are deeds that you can download from the recorder's office and fill in the blanks. You can handwrite it and fill in the blanks. And as long as it's executed correctly, you have a notary, the signature, it could be valid. But it's all in whether that fits, right? And what are the other consequences and ramifications of just filing that deed? Once you file it, before you file it, once it's signed and notarized, before you even record it, it's a done deal. Now the ramifications are in. It's really difficult to undo, and some of it you can't. So you have to be very careful. Is it the right situation? All right. So all of these three, the trust, the transfer on death deed, or the quitclaim deed, all options to do this deathbed planning for our homeowners on hospice and hasn't gotten around to dealing with the house, and finally they're really pushed into it, and the family's like freaking out because they're going to have to deal with the probate afterwards and all the unintended consequences, the long court, the expense, and all the things and all the horror stories they've heard about probate. Shoot, that's going to happen to their dad's house. So we want to pick one of these three options, which is going to work. But before we do that, we have to remember that the big landmine here is the easy collateral attack on deathbed planning is that the person had no idea what they were doing. They were not in the right mindset, right? They're on death's door. They're maybe highly medicated. Maybe they're already cognitive issues. They're out of it. And there's also the fear factor, environment, all the things. They're in and out of lucidity. These are all challenging situations because it could be very easy to attack the capacity of that individual in signing a document. Do they understand what they were signing? Yes, they put their names there. That's their name. Yes, there was a notary, but did they understand? The notary is not charged with making a decision in regards to capacity. Now, lots of notaries will tell you, hey, if I get a whiff that this person's kind of out of it, there might be capacity issues, I'm not notarizing. That is a protective measure by the notary to do something smart. They don't want to get dragged into litigation. So they're just not going to sign on as a witness to this, right? That's not saying that they've determined that there's incapacity, so they're not doing it, or they determined there's no incapacity, that's why they've notarized it. No, they're just there to ensure that the person signing is the person who they say that they are, and there's the ID and all that. That they're just notarizing. That's it. So there can still be a challenge to capacity. That's a problem, of course, on a deathbed. And it's a problem because now it's a he said, she said, right? The person who died's not there to say, hey, I had capacity. I knew what I was doing. They've passed away. So now we have to prove that that person knew what was going on. And if we haven't taken the right measures to do that, then it's going to maybe be undone what we were doing. And we're in court and it's getting undone. Now we're back in probate court. But we're in court first, right? We're in probate court anyway because someone's challenged it. Someone has filed a lawsuit challenging the capacity of the decedent, and they filed a petition for instructions to invalidate that document, whether it's a trust, whether it's a transfer on death deed, whether it's a quitclaim deed. Somebody is seeking to invalidate that document. Now we have to have like this trial on this issue, and we need witnesses. It's subject to discovery. This thing doesn't happen overnight. It's going to be super stressful. And what's happening to the house in the meantime? Nothing. It's not going to be sold. No title company is going to sign off on a title insurance policy to sell this house, because they don't know who the owner is. It's being challenged, these documents. So everyone's going to back off, and that house is just going to sit there. Now, it might not be a problem if that was the intention, that someone was going to move in and be there, but certainly it's going to be a problem if the understanding was we're going to sell the house and beneficiaries were going to get inheritances, or we're relying on the inheritance, not like counting on it, but in the sense that, oh boy, I'm going to go get a big spending spree, but counting on it from the standpoint they have financial needs. They're otherwise destitute, or they have these big medical bills and debt they have to settle, or the house is a reverse mortgage. And the mortgage company is pounding on the door saying, hey, you got to pay us back. Or it's just a regular mortgage, same deal. Mortgage company saying, hey, we're at the bank, you have to pay us back, or we're going to foreclose on the house. And guess what? In California, non-judicial foreclosure action. So that means they give you 90 days. If you don't satisfy the debt, you lose the house. Oh my gosh, how can we get the trial done in 90 days? No, you can't. So you see the challenge here. So now we're going to have a fight over documents, over a house that's not going to exist. later. And then people are going to start suing each other for negligence, for malpractice. If you're an attorney listening, hello, this is a big potential malpractice landmine to step on. And then people are going to start suing each other personally to make up the difference. And so how do I know this? I've seen it. So it does happen. It's true. It happens. So we got to plan for that. So that goes for any of these documents. We have to treat them carefully and treat them like we're going to be in trial somewhere down the road, and we have to supply evidence. Maybe you record audio, video. Of course, make sure you get consent. You don't want to step on that landmine because that's a crime in California. Never mind a civil tort and not being admissible in court. So you got to do it correctly. So again, you want to hire an expert in this situation that's been through it before and done it successfully. Then, okay, well, which of these options are we going to pursue? Well, you leave that to the expert, right, to tell you the best one. But there, are challenges throughout. Like I mentioned, if the person is having a difficult time understanding and you can't be able to testify later or admit somehow that person understood every one of the pages that involved that legal document, then might not be a good idea for a trust. It's going to be too long, even if we used the short versions those are like 40, 50 pages long. That might be a bit much and easily attacked later because did the person read every page? Would you have it back and forth on every page? No, you didn't. They just signed because you said sign here, or you kind of explained a little bit, but you didn't explain all of it. And they didn't read all. They couldn't read all of it. It's challenging. Maybe that's a bad option. Transfer on death deed. Well, that's shorter. It's a couple pages. But we have to make sure that they understand the implication of that. And also, you got to know that after the person passes away, there's recording requirements, all that on the front, and you got to record it within 60 days of the signature, or it's not valid. You have to list certain things on the transfer and death deed, or it's not valid. There's no way to cure that later. And then, of course, when the homeowner passes away, then you have to record certain notices that you've provided the other potential heirs of that person. And if you don't know where they are and track them down, then good luck. You can't pass go and doing anything with that house until you can prove that you've notified them or made good faith efforts to notify them. And you might have to wait 5 years because that's in the code. So again, we've run into challenges there. So that only works if, hey, I know all the heirs. I have all their contact information. This is not going to be a problem. Okay. Then that might be an option. So you got to go through that analysis first. And of course, they have to be served and noticed a certain way too, or it doesn't work. So again, working with a professional. Quitclaim deed. I leave that last because this is really not an option in my mind. Because if we were going to record something with the recorder's office, we'll do a transfer and death deed. Why? Well, there's tax considerations. There's this little thing called capital gains tax and a great benefit called a step up in cost basis. Well, what's that, Kevin? Well, when you are now the owner of the house, if you're the beneficiaries, if you're the homeowner saying, hey, I know I'm going to die very soon here, and on my death, I want to make sure that the people I love get this house, my children, my beneficiaries. I also want them to get a tax advantage because I know they're going to sell the house, or they'll probably sell the house at some point. And when they sell the house, I don't want them to get hit with a big capital gains tax bill, because when I bought the house, it was a lot cheaper than it is now. There's a lot of that going on, right? We live in Southern California, where our main office is, but that's Northern California. We also have offices all across California, right? We're in a state where there's appreciating real estate. And so there's going to be a gain. So if the homeowner sold it, then there would be he or she would be taxed as a gain. So my example, the dad, if he sold the property, would be taxed there would be a gain, it would be tax capital gains. Well, we want our children or beneficiaries not to get that capital gains tax because it would be large. If it's appreciated $1 million, you're dealing with $330,000 of capital gains tax. If we include federal and California state tax right there, straight off the bat. Well, even more, 37 probably as it works out. So over a third of that profit is going to get taxed, or on the gain. So that's a big chunk, and that's with my $1 million example. So bought the house for $200,000. It's not 1.2. That's a very conceivable situation, right? We're all like, oh yeah, I know a house like that. That's a big tax bill. Never mind the houses that appreciated even more, bigger tax bill. So we want to erase that gain, that taxable gain. We want to then give the house at death, meaning after death. At the moment of death, boom, it then legally transfers to our beneficiaries. Then there's what's called a step-up in basis that zeroes out the taxable capital gain. That means the gain is measured from the date of death value, not from the date of purchase value. So that's a huge, my example, that $1 million gain is wiped out because now they're going to start measuring the gain from 1.2, which is the date on death fair market value. How do you know that value? You just don't look on Zillow, you get an appraisal. Like if you hire an appraiser for a few $100 and you get that, right? A few hundred, 600, 700. It not a big bill to get that number to give to the IRS. So you don't, then you get that benefit. That's huge. Can't do that with a quitclaim deed. Why? Because you're not giving it at death, you're giving it in life. So all you're doing is you're giving the property and the cost basis. So that 200,000 in my example, dad bought the house $200,000 decades ago. Well, now children now have 200,000 cost basis. So when they go to sell the house after dad dies, they're paying the big tax bill, big capital gains tax bill. They don't get a step up in basis. That's a raw deal because they got the house, but not the tax benefit. And so the quick claim deed is out. Even though it's easy, some people call it a quick claim deed. It's not, it's quit claim deed. But we call it, some people I think call it quick claim deed because it's easy. I can do it quickly. And that quickly is a problem. Haste makes waste, certainly here. So that option is not available. So it's really down to two, trust or transfer death deed. And survey says, it depends. Big lawyer answer. So the moral of the story here is hire an attorney that knows what they're doing, that has gone through the experience with other clients, that knows the right solution for the situation so that you're getting the result that you want or your parent wants, your loved one wants. I want the house to go to this person or group of people. That's the result I want. Great. The professional will tell you which is the right result. And here, it's not just any estate planning attorney. I really, really highly encourage an elder law attorney. Why? Because of the capacity issues. And particularly an attorney also that has litigation experience because they know the things, the litigation landmines to avoid and doing this and executing it. Okay, well, later on, we might have to put on this evidence. And so they're going to know what to do now to preserve that evidence for later and to do it in a way to situate it so it maybe even never goes to trial. It never becomes a lawsuit. Or if there's a lawsuit, that it fizzles very quickly because once discovery is had, there's no avenue for argument anymore. So all to say, this came out of a phone call today. So we're going to see tomorrow or Friday where I'm going to make good on what my advice is, and if they're hiring me to help and go through this analysis and do that, I'll have a recap of how it goes and keep you updated. But right now, these are the things that are reaching us, and I know they're in your life, either you personally, people that are in your circle, or your clients. So my hope is that this was a benefit and value to you so you could take out there in the universe. Use us as a resource. We're here. So, right. This is also a video to say, hey, we can help if we're the right fit, obviously. So we're here to help in these situations. If you have any questions about this, if you're watching on LinkedIn, put in the comments. You're watching YouTube, put in the comments. Wherever you're watching social land, put in the comments, and someone on my team will in there. To kind of depends, but we will respond to your questions. And specific questions, just know that we're going to say, hey, let's talk. Let's have a consultation, have a meeting. I'm not going to answer it necessarily in the feed, but I'll know that you have a question and that you need some help. So just put the question in there. We'll answer it if it's something that we can answer generally, or if we need to meet personally, we'll take care of that. So like I said, here to help. My name's Kevin Snyder. If I haven't mentioned that, you don't see it in the socials. I'm an estate planning, elder law, and estate litigation attorney. We help build dreams, implement dreams, and protect dreams for our clients, and we're happy to help where we can. In the meantime, go out there and keep being amazing.